in the last video about Rule 9610, we had highlighted about the council making announcement in its 54th GST Council meeting. There were some interesting announcements with respect to omission of this Rule 9610, which is a great benefit for the exporters. Also, how you could make effective efforts so that you could put everything in place by getting reassessment of the bill of entry. There is now yet another very interesting development of Gujarat High Court, which has just happened by way of pronouncement of the decision of the Honorable Gujarat High Court, which just happened on 19th of September 2024 at about 3:30 p.m. And Gujarat High Court was kind enough to review the earlier decision in the case of Cosmo Films versus Union of India, which was argued by us before Gujarat High Court. When we moved this review petition before the Gujarat High Court, we had raised 8 fundamental aspects in paragraph where we found that there is a mistake apparent on the face of the record in the order. This matter was argued at length before the Gujarat High Court some time back. And today we are pleased and we are honored to tell to our viewers that Gujarat High Court has passed a remarkable decision to review its own order. And this will go a long way towards justice for the Indian exporters. We are proud to argue this matter before Gujarat High Court, and we, with all humility, would want to thank the Gujarat High Court and all our clients and all our participants and viewers who have been keenly watching us on our arguments with respect to Rule 9610. With that background, let us now go ahead and understand what Gujarat High Court just pronounced with respect to the review of its order in Cosmo Films. Gujarat High Court very categorically said that with respect to all 8 points which were raised in the review petition, there appears to be a mistake apparent on the face of record, and Gujarat High Court had agreed to pass a detailed order with respect to changes in these 8 paragraphs, which are at paragraph 4.4, 4.5, 4.6, 8.3, 8.10, 8.13, 8.15, and paragraph 9. This was pronounced in the open court. Certain details were also shared in the open court. But before we go on to those details and also wait for the final order to come, let us just take a pause and explain that what were the fundamental points which we had raised before Gujarat High Court in terms of the fundamental mistakes apparent from the face of record. If you remember, and if you see our last video, we had raised the fundamental point about notification 16 of 2020, which according to us was not present at the time when this matter was argued. This notification is with respect to the BCD and the IGST, and if you claim benefit only of to the extent of, so basically it says that if you are claiming benefit and exemption for BCD, then there is no problem. Only IGST was a problem. And if you have taken for BCD, then the benefit continues. This notification came later at the time when these arguments were taking place. This notification was not in place, and this was part of the order. So our fundamental point was that it should not be part of the order because we may have to agitate that with respect to lack of intelligible differentiate, etc. So that was with respect to notification number 16 of 2020, which we had raised the fundamental point. The second point which was raised by us was with respect to notification 54, which came into effect on 9th of October 2018. We very categorically emphasized before the Honorable Court that the effective date of this notification is only prospective, and this notification comes only with effect from 9th of October 2018. And hence, wherever the order refers to Rule 9610, which may have been governed by different notifications, say, for instance, 53 of 2018, which had prospective effect, will come into play. It is reiterated that the language of notification 54, which is prospective, is different from the language of the notification 53 and the other notifications which implemented 9610. And hence, it was very important for us to get the order corrected from the perspective of determination of the quantum, even when we talk about the reassessment of bill of entries, etc., because both the notifications, the validity of the period, etc., will come into play now. And we are deeply honored and obliged to get this order for industry. The correction has been pronounced today with respect to the prospective applicability of notification 54 of 2018, and this is indeed an important point for us. There have been a lot of questions with respect to interest applicability on these transactions, and that aspect was never before the Gujarat High Court in the earlier writ petition. But however, there were certain findings with respect to the interest. While the reassessment or change to Rule 86 4B may have some interest applicability, but interest remains a separate battle altogether, keeping in mind revenue neutrality and also the provisions of Section 50, which provides for non-levy of interest in certain cases when it pertains to refund. And hence, any implication or findings or observation in the High Court order with respect to interest, we felt that it is our duty to highlight before the court, and we did that. And this point has also been addressed with respect to interest by the Honorable High Court in the review petition argued by us. The next point was with respect to the rules which have come into force with effect from 9th of October 2018, and there was no ambiguity with respect to the substitution of Rule 9610 to apply prospectivity before this court. And the issue before the court was only with respect to validity of notification 54 of 2018 and not with regard to applicability of its date. That question was never before the court, and hence it was pointed out by us that it was a mistake apparent on record to have been committed in the impugned judgment passed by the court, wherein it was stated that notification 54 issued by a respondent was with effect from 23/10/2017, whereas this notification was only prospective. And so from that perspective also, there have been changes which have been made. In terms of the specific changes, there have been changes, I will repeat, in paragraphs 4.4, 4.5, 4.6, 8.3, 8.10, 8.13, 8.15, and paragraph 9. Now, let us understand that what these changes predominantly would mean. So first of all, the reference to the earlier date of 23rd of October 2017 is deleted, which means the applicability of the notification 54 being prospective has been made very clear by deletion of these words at separate places. The order removes the reference to this date and also very clearly provides that 54 notification is prospective, and hence all accordingly changes have been made. So going into details, in paragraph 4.4, the word with effect from 23rd of October 2017 appearing in the third line shall stand deleted. In paragraph 4.5, the word with effect from 1st of July 17 appearing in the third line from the bottom shall stand deleted. In paragraph 4.6, words and with effect from 23rd of October 2017 are deleted. In paragraph 8.3, the word with effect from 1/4/2017 appearing in the second line shall be read as 1/7/2017. In paragraph 8.10, the word retrospectively shall be substituted with the word prospectively, and the word with effect from 23rd 10/2017 stands deleted. Para 8.13 of the judgment and order shall now read as follows. Notification 48 dated 18th October 2017 has declared the following goods and explanation thereto states that, and it goes on to say about the chapter 4 of foreign trade policy, etc. This gets changed now, and the important aspect is with respect to the applicability of the dates of various notifications, including that of 54 of 2018, that gets addressed. In paragraph 8.15, para 8.15 shall be deleted from the judgment as notification 16 of 2020 was not available when the matter was heard, and accordingly the said paragraph is not to be considered as part of the judgment. And this is indeed very important, because at some stage, possibly when we are arguing on the constitutional validity before the Supreme Court, the lack of intelligible differential between the basic customs duty and the IGST may come into play. And hence, at that point of time, this notification 16 of 2022 will have to be argued, because the benefit has been given with respect to applicability of BCD, and IGST is treated not at par with BCD. So that element will come, and hence deletion of paragraph 8.15 was very important. In paragraph 9, first, the words with effect from 23rd October 2017 shall be deleted from last three lines. Notification 54 of 2018 is therefore held to be effective with effect from the earlier date. That gets deleted, and that the problem is addressed. Also, very importantly, that part of the judgment which pertains to the interest being applicable is being deleted, which means that as far as the interest applicability on these transactions is concerned, the challenge remains, the argument will remain. The judgment and order dated 2010-2020 shall stand modified to the aforesaid extent. Application is accordingly allowed to the aforesaid extent, etc. Which means on 8 points, predominantly the order has been reviewed, the final order has been passed in the review, and this will help the Indian exporters. We thank you for following us on our YouTube channel. For any queries with respect to Rule 9610 or anything apart from that also, you may subscribe to our channel or drop us an email on abhishek@rastogichambers.com. Please feel free to drop a WhatsApp message in case you want your queries to be resolved on 9820241489. I repeat, my mobile number 9820241489. Thank you. Have a great evening ahead.